Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. If you're studying for the bar exam, this case summary is one you need to understand cold. Imagine you sell high-value goods to a reputable company, only to find out it was a scammer using a similar name. Now, an innocent third party has your items and refuses to give them back. In this video, we break down the landmark Cundy v. Lindsay case to show you who the law protects when identity theft ruins a deal. Before we look at the law, let's look at how the fraud actually happened, because these same tactics are used in modern business scams today. In this case, a man named Blenkarn rented a room on the same street as a famous firm called Blenkarn & Co. He ordered goods by signing his name to look exactly like the reputable company's signature. This is a classic look-alike scam where a fraudster rides on the creditworthiness of a legitimate business. If you receive an order today that looks slightly off, always verify the exact address and spelling. The court focused on the fact that the sellers, Lindsay & Co., intended to deal specifically with Blenkarn & Co., not the fraudster. This is called a mistake of identity. It's different from a mistake of attributes, like thinking someone is rich when they're poor. In business, if you think you're selling to Company A, but Company B is actually the one at the table, the legal foundation of the deal is at risk. This case happened entirely through letters, which made the identity mistake easier to prove. When you deal with someone face-to-face, the law often assumes you intended to contract with the person standing in front of you, regardless of their name. In the digital age, email and paper trails are more like the Cundy case, making identity verification a top priority for remote transactions. The biggest financial impact of this case comes down to one word. Was the contract void or voidable? The difference determines if you get your money back. The court ruled that because there was a mistake of identity, no contract ever existed between Lindsay and the fraudster. It was void ab initio, or void from the beginning. This means no legal rights were ever transferred. It's as if the transaction never happened in the eyes of the law, which is the best-case scenario for a defrauded seller. If the contract had been merely voidable, it would have been valid until the seller took steps to cancel it. In many fraud cases, if the fraudster sells the goods to an innocent buyer before the seller cancels, the innocent buyer gets to keep them. Understanding this distinction helps you realize why acting fast when you suspect fraud is a financial necessity. Because the original contract was void, the fraudster never actually owned the goods. If you don't own something, you can't sell it to someone else. This is the Nemo dates rule in action. For businesses, this means that even if a buyer pays a fraudster in good faith, they might still have to return the goods to the original owner without a refund. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Now, let's look at Cundy, the person who bought the goods from the fraudster. They did nothing wrong, yet they lost everything. The full phrase is Nemo dat quod non habet, meaning no one gives what they don't have. Since the fraudster never had legal title, he couldn't give title to Cundy. This is a harsh reality for buyers. If you buy inventory from an unverified source, you're taking on the risk that the seller doesn't actually own what they're selling. In cases like this, the court has to choose which innocent party suffers, the original seller or the final buyer. In Cundy v. Lindsay, the court chose to protect the original owner. This highlights a critical trade-off in law. Protecting property rights is often seen as more important than protecting the flow of commerce or good faith purchases. To avoid being in Cundy's position, you have to verify the chain of title for large purchases. Ask for original invoices or proof of purchase from the supplier's supplier. If a deal seems too good to be true, or the seller is vague about how they acquired the goods, that's a massive red flag that could lead to you losing your investment. We don't use quill pens anymore, but the lessons from 1878 are more relevant than ever in our era of digital impersonation. Modern companies use Know Your Business protocols to prevent the Cundy scenario. This involves checking business registration numbers, verifying physical addresses, and ensuring the bank account name matches the company name exactly. A small discrepancy in a business name could be the difference between a secured deal and a total loss. Today, Blenkarn wouldn't use a letter. He would use a spoofed email address that looks like a CEO's. Always check the domain carefully. If the real company is company.coms and the order comes from companyinc.com, you're likely looking at a modern-day Cundy v. Lindsay setup. Never ship goods based on an email alone without secondary verification. One way businesses manage this risk is through credit insurance. If you're defrauded or a buyer defaults, insurance can cover the loss. It's an added cost, but it provides a safety net when the legal system's void versus voidable distinctions might otherwise leave you empty-handed. Always compare the cost of insurance against the value of your most frequent high-risk shipments. If you find yourself in this situation, you need to know how to move forward legally to recover your assets. If someone has your goods and refuses to return them because they bought them from a fraudster, you may have a claim for conversion. This is a civil wrong where someone may help with your property as their own. In the Cundy case, Lindsay sued for conversion to get the value of the goods back from the third party who'd already sold them. Identity fraud cases are complex because they involve two victims and one criminal who is usually may improve. A commercial lawyer can help you determine if your contract is void or voidable based on the specific facts. This determination is the pivot points for whether you sue the third party or just write off the loss for tax purposes. If you suspect you've been scammed, the first step is to freeze all shipments and notify your bank. Next, document every piece of communication, emails, letters, and invoices. This paper trail is what the court uses to decide if there was a true mistake of identity or just a bad business decision. Don't wait. The longer you delay, the harder it's to trace the goods. Cundy v. Lindsay teaches us that in the world of business, knowing exactly who you're dealing with is just as important as the price of the goods. By verifying identities and understanding how title transfers, you can avoid being the victim or the innocent buyer who loses everything. If this guide helped you understand the risks of identity fraud in contracts, like and subscribe for more practical legal breakdowns. For more resources on protecting your business interests, visit Bar Exam HQ. If this helped, like the video and comment with the next case you want summarized. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.